You've seen the headlines: green card holders being deported, permanent residents losing their status, people who've lived in America for years suddenly facing removal. Your phone is buzzing with messages from family and friends asking if it's true, if they're safe, if everything they worked for is about to disappear. I understand that fear, and I'm here to give you the facts, not the panic. My name is Saqib, and this is Global Immigration Updates, where we cut through the noise and give you clear, fact-based immigration information without the rumors, without the politics, and without the panic. What's actually happening with green card holders in 2026 is serious, but it's also much more specific and limited than what you're seeing on social media. Let me walk you through exactly what's going on, who's actually affected, and what you need to know to protect yourself and your family. First, let's be absolutely clear about something fundamental. A green card, officially called lawful permanent residence, is one of the strongest immigration statuses you can have in the United States. It gives you the right to live and work permanently in America. It's not temporary, it's not conditional for most people, and it cannot be taken away easily or randomly. There are legal protections, there's due process, and there are very specific circumstances under which a green card holder can face deportation. This is not a situation where immigration officers are going door to door removing people who have done nothing wrong. So what's actually changed? What we're seeing in 2026 is not a new law that suddenly makes all green card holders deportable. Instead, what's happening is increased enforcement of rules that have always existed, combined with stricter scrutiny of certain categories of green card holders who may have issues in their immigration history or current behavior. The rules themselves are not new. The enforcement priority and the resources dedicated to finding and removing certain green card holders have intensified. Let me explain the circumstances under which a green card holder has always been deportable under U.S. immigration law, because understanding this is crucial to knowing whether you or someone you know is actually at risk. A green card holder can be placed in removal proceedings if they commit certain crimes. These are not minor traffic violations. We're talking about serious crimes classified as aggravated felonies under immigration law, crimes involving moral turpitude, drug offenses, domestic violence, firearms offenses, and other serious criminal conduct. Immigration law has a very specific definition of what crimes make someone deportable, and these definitions have been in place for years. A green card holder can also face deportation if they committed immigration fraud to obtain their green card. This means lying on your application, using fake documents, entering into a fraudulent marriage for immigration benefits, or concealing information that would have made you ineligible. If USCIS or immigration enforcement discovers fraud in how you obtained your status, even years later, that can trigger removal proceedings. Another ground for deportation that many people don't fully understand is abandonment of permanent residence. If you're a green card holder and you leave the United States for an extended period without obtaining a re-entry permit, or if you establish your primary residence outside the US, immigration officers can determine that you've abandoned your green card. This is especially relevant now because enforcement agencies are paying closer attention to green card holders who spend most of their time outside the United States while claiming to maintain permanent residence here. Green card holders can also be deportable if they become what's called a public charge after admission, though this is complex and narrowly applied. It generally involves becoming primarily dependent on government cash assistance programs for an extended period, but this ground is rarely used and has many legal protections around it. There's also a category that applies to people who engage in activities that threaten national security, such as terrorism-related activity, espionage, or certain types of criminal gang involvement. These cases are rare, but they are taken extremely seriously. What's happening in 2026 is that immigration enforcement agencies have increased resources and have made it a priority to identify and remove green card holders who fall into these categories, particularly those with criminal convictions and those suspected of immigration fraud. This is not a random sweep. This is targeted enforcement based on existing law. Here's what's being misunderstood and exaggerated on social media. People are seeing headlines about increased deportations of green card holders and assuming this means anyone with a green card is now at risk. That's simply not true. If you obtained your green card legitimately, if you have not committed serious crimes, if you maintain your residence in the United States and follow the conditions of your permanent residence, you are not suddenly in danger of deportation because of new policies in 2026. What is true is that enforcement has become more aggressive in pursuing cases that previously might have been lower priority. For example, someone who committed a deportable offense years ago but was never placed in removal proceedings might now find themselves receiving a notice to appear in immigration court. Someone who obtained a green card through a marriage that immigration now suspects was fraudulent might face increased scrutiny and investigation. There's also increased coordination between local law enforcement and federal immigration authorities in some jurisdictions, which means that green card holders who are arrested for crimes may be flagged for immigration review more quickly than in the past. This doesn't create new grounds for deportation, but it does mean that existing grounds are being enforced more consistently. Let me address some specific rumors that are causing unnecessary panic. Rumor 1. Green card holders who travel outside the US will not be allowed back in. This is false. Green card holders have the right to travel internationally and return to the United States. However, if you've been outside the US for more than 6 months, especially more than 1 year, you may face additional questions at the port of entry about whether you've abandoned your residence. If you plan extended travel, obtain a re-entry permit before leaving. If you're returning after a long absence, be prepared to show evidence that you maintain ties to the United States. Rumor 2. Green card holders are being deported for minor traffic violations or old misdemeanors. This is misleading. Minor traffic violations like speeding tickets are not grounds for deportation. However, certain driving-related offenses, such as DUI, can be considered crimes involving moral turpitude or aggravated felonies, depending on the specific circumstances and state law. The issue is not every minor infraction, but specific criminal convictions that immigration law classifies as deportable offenses. Rumor 3. If you're a green card holder and you apply for citizenship, you'll be deported if there's any problem with your case. This fear is preventing some people from naturalizing, which is unfortunate. When you apply for citizenship, USCIS does review your entire immigration history. If they discover fraud or criminal issues that make you deportable, yes, that could lead to removal proceedings. However, if you obtained your green card legitimately and you meet the requirements for citizenship, applying for naturalization does not put you at increased risk. In fact, becoming a US citizen provides much stronger protection because citizens cannot be deported. Rumor 4. Green card holders who receive any government benefits will be deported under public charge rules. This is a misunderstanding of how public charge works. Public charge inadmissibility applies primarily at the time someone is applying for a green card or seeking admission to the United States. Once you have a green card, the public charge ground for deportation is extremely narrow and requires becoming primarily dependent on government cash assistance for income maintenance, which is very different from receiving benefits you're legally eligible for, such as emergency medical care, disaster relief, or benefits earned through work like Social Security. So who is actually at risk right now? You are at higher risk of deportation if you are a green card holder and you have been convicted of crimes that immigration law defines as aggravated felonies or crimes involving moral turpitude. These include but are not limited to drug trafficking, violent crimes, sexual offenses, fraud offenses involving more than $10,000, theft or burglary offenses, with certain sentence lengths, domestic violence, child abuse, firearms offenses, and many others. If you have any criminal conviction, even if it seemed minor at the time, or even if it happened years ago, you should consult with an immigration attorney to understand whether it creates deportability issues. You are at higher risk if you obtained your green card through marriage, and that marriage ended quickly, especially if USCIS suspects the marriage was entered into solely for immigration purposes. Fraud investigations can be opened even years after a green card is approved, and the burden of proof shifts to you to show the marriage was legitimate. You are at higher risk if you have spent extended periods outside the United States without maintaining clear ties here or without obtaining proper documentation like a re-entry permit. Immigration officers at ports of entry have the authority to question whether you've abandoned your permanent residence, and if they determine you have, your green card can be taken at the border. You are at higher risk if you lied on your green card application, failed to disclose previous immigration violations, prior criminal history, or other material facts that could have affected your eligibility. Even if the lie seemed small to you, material misrepresentation is a serious ground for deportation. Now let me be very clear about who is not at risk. If you are a green card holder who obtained your status legitimately, who has not committed deportable crimes, who maintains your primary residence in the United States, who files your taxes, who follows all the conditions of your permanent residence, the policies in 2026 do not create new risks for you. You are not going to be deported simply for being a green card holder. If you have old traffic tickets, if you once received food assistance during a difficult time, if you traveled outside the US for a vacation and came back, if you've had normal life circumstances like job changes or moving to a different state, these things do not make you deportable. The fear and confusion come from not understanding the difference between enforcement priorities changing and the actual law changing. The law regarding who is deportable has not fundamentally changed. What has changed is how aggressively certain violations are being pursued and how many resources are being dedicated to enforcement. What should you actually do with this information? First, if you have any criminal history at all, even minor convictions, even expunged cases, even things that happened decades ago, consult with an immigration attorney. Do not assume something is too old or too minor to matter. Immigration law's definition of deportable offenses is very specific and sometimes includes things that seem minor under criminal law. An attorney can review your specific situation and tell you whether you have exposure. Second, if you obtained your green card in a way that you know involved any misrepresentation, any fraud, any shortcuts that weren't legitimate, speak with an immigration attorney immediately. Understand what your risks are and what options you might have. Sometimes there are legal remedies, sometimes there are waivers available, but you need professional guidance. Third, if you are eligible to apply for U.S. citizenship, seriously consider doing so. Citizenship provides much greater protection than permanent residence. Citizens cannot be deported. Citizens cannot have their status questioned or revoked, except in extremely rare cases involving fraud in the naturalization process itself. If you've had your green card for 5 years, or 3 years if you got it through marriage to a U.S. citizen, and you meet the other requirements for naturalization, applying for citizenship is often the best way to secure your long-term status. Fourth, maintain clear evidence that the United States is your primary residence. Keep documentation of your ties here, your employment, your housing, your family connections, your financial accounts, your memberships and activities. If you travel internationally, keep trips reasonably short and maintain your connections here. If you need to be outside the US for more than 6 months, apply for a re-entry permit before you leave. Fifth, stay informed through official sources. USCIS.gov is the official website for US citizenship and immigration services. That's where you'll find accurate information about policies, procedures, and requirements. The State Department website has information about travel and visas. Immigration court information is available through the Department of Justice's Executive Office for Immigration Review. Do not rely on social media posts. Do not rely on rumors from friends or family, and be very cautious about information from unofficial sources that might be trying to create panic. Sixth, if you receive any communication from USCIS, from Immigration and Customs Enforcement, or from Immigration Court, take it seriously and respond appropriately. Do not ignore official notices. If you receive a notice to appear in Immigration Court, that is the beginning of removal proceedings, and you absolutely need an attorney. If you receive a request for evidence or a notice of intent to revoke your green card, consult with an attorney before responding. Let me give you some reassurance here, because I know this topic creates real anxiety. Immigration law in the United States has due process protections. If the government wants to deport you, they have to prove their case in immigration court. You have the right to be represented by an attorney at your own expense. You have the right to present evidence and witnesses. You have the right to appeal if you lose. This is not a system where people disappear overnight without any legal process. The grounds for deporting a green card holder are specific and limited. They've been part of immigration law for many years. What's happening now is enforcement of existing rules, not creation of new rules that suddenly make everyone vulnerable. If you have followed the law, if you obtained your status legitimately, if you've maintained your residence properly, the system is not designed to remove you. That said, if you do fall into a category where you might be at risk, the absolute worst thing you can do is ignore the situation or hope it goes away. Immigration enforcement has more resources and more sophisticated tracking systems than ever before. Cases that might have been overlooked in the past are now being pursued. If you have any reason to think you might have an immigration issue, get proper legal help sooner rather than later. One more important point: be very careful about who you trust for immigration help. There are many people who call themselves immigration consultants or notarios who are not actually lawyers and cannot provide legal representation in immigration court. If you're facing potential deportation, you need a licensed attorney who specializes in immigration law. You can find qualified attorneys through the American Immigration Lawyers Association website, through local bar association referral services, or through non-profit legal aid organizations if you cannot afford a private attorney. The situation with green card holders and deportation in 2026 is real, but it's also specific. It's not a crisis affecting everyone with a green card. It's increased enforcement affecting people who have committed deportable offenses or who have issues with how they obtained their status. Understanding the difference between those two things is crucial to knowing whether you need to take action or whether you can simply continue living your life as a lawful permanent resident. Immigration rules do not change overnight. There are legal processes, there are protections, and there are ways to address problems if they exist. The key is staying informed with accurate information from official sources, not from social media panic, and getting professional help if your situation actually requires it. If this video helped you understand what's really happening, please subscribe to Global Immigration Updates and turn on notifications so you don't miss important immigration news and analysis. Share this video with anyone you know who might be worried about their green card status or who's seen the scary headlines and doesn't know what to believe. And please leave your immigration questions in the comments. I read them, and your questions help me know what topics to cover next to keep you informed and reduce the fear and confusion that rumors create. Stay informed, stay calm, and remember that accurate information is your best protection.